who you are, where you're from, et cetera, et cetera.
Perfect.
So, welcome.
All right. Thank you, Chair Durfee and members of the committee. I appreciate the invitation to come in and testify. My name is Angela Zajkowski. I am the director of the Vermont Landlords Association. We're a statewide trade organization for housing providers in Vermont. I'm also a practicing attorney, and I have a private practice in Shelburne, Vermont, where I provide legal services and support to housing providers. That is sort of the exclusive subject of my practice these days. So I have been asked to come testify about H537. I was going to focus my comments exclusively on Section 3 as it relates to the landlord-tenant relationship, sort of common unit developments in communities are sort of outside my practice area and my scope of knowledge. So.
That's fine. No, we wouldn't want you to speak to an area that you weren't comfortable speaking to.
Perfect. So I'd first like to say I think it's important that people have access to food and have the ability to provide food for themselves and their families. And I think we have a lot of information and reports about food insecurity in Vermont and, you know, ways to help people get to that place. Uh, I don't think I've ever been before this committee before because I work primarily in the housing realm. And the landlord-tenant relationship can actually be quite contentious at times and can be sort of tricky to navigate for both landlords and tenants. I know the Housing Committee is currently working on a large landlord-tenant bill. Um, and so I think while there are a lot of things that have been thoughtfully put into this bill in Section 3, I think it has the potential to create some conflict where it doesn't need to be and perhaps create some challenges for both housing providers and renters in this situation. So my experience right now is landlords and tenants deal with growing of food or plants or having gardens on sort of a case by case basis. I don't see a lot of disputes or conflicts regarding that. Not all properties are set up for this type of even in planter box situations. And so it's usually a discussion that landlords and tenants have if it's something the tenant wants to do. If the property is able to support it and it makes sense, they work out the details of that between themselves. I don't know if the committee's been hearing complaints about tenants not being able to put in vegetable planters if they ask for it or not, but that hasn't been sort of what I've seen in these situations. What I have some concerns about is how something like this would get handled if there's a problem. And so it's always, how do you deal with a problem with this relationship? And the only tool that's available to a landlord is an eviction. So if a tenant were not doing what they're supposed to under this section, you know, putting vegetable garden where it's creating a health or safety hazard or where it's interfering with tenant parking, the landlord doesn't actually have the ability to go in and just move those planters. That's the tenant's property. They're not allowed to do that. And their recourse is to send them a violation notice, which under Vermont law currently is a 30-day notice. And then if there's not compliance, to start an eviction case in the court, which is about a 6-month process. So this, I think, has the potential for creating some more avenues for conflict and also for creating some situations where the tenant says, well, it's in the statute, I can just do it even without permission of the landlord, which is one of the things that we run into occasionally. So I think it's a I think it's a fantastic goal, and I think that there may be some points here that there could be some clarification. Perhaps it's as simple as permission for landlord to be able to move or fix the situation without liability to the tenant. Maybe it's something where landlord's allowed to collect extra deposits in these situations to ensure that the tenant's complying and removing and not creating a problem. But I think it could create more avenues of friction between these two parties than needs to be there.
So we're always looking for ways to find common ground.
Mhm.
And let me just say thank you before I go any further. Thank you for that testimony and providing some context and background. Um, I got the bill pulled up on my laptop here. It's H537, and section 3, as you're talking about, says this is page 5 if anybody's following along. Line 11, a landlord shall permit a tenant to grow a vegetable garden in portable containers approved by the landlord in the tenant's private area. So that gives some protection there, I guess, to the landlord by saying pretty definitively, I think, that the landlord would have to sign off on that. I can imagine that you might run into a challenge if the landlord said no, and then the tenant tried to, find something that would work and wasn't able to, if they kept hearing no.
Right.
Uh,
I think I would, if we're talking specific language, in that particular section, lines 11 and into 12, tenant's private area, that's not really language that we use in housing. So it would be probably, something like portable containers approved by landlord in tenant's rented premises or rented space. I mean, I could probably flesh that out a little bit more, but that particular language is not something we see in the housing context.
If we were to take your suggestion there, would that be sufficient to, in your mind anyway, make this workable?
I think my request would be to give us maybe some not teeth, that's not really the word I'm looking for, but some ability to deal with a situation where a tenant has placed garden that's interfering. So, I'm looking at 3 and 4 on page 6 for section C. Some ability for the landlord to be able to move or remove those items without liability to the tenant if they are impeding or causing a problem. I think what we're looking for is the ability to be able to manage the situation on site that maybe doesn't involve an eviction. Landlords don't want to have to do that, but they also need to be able to manage their property and the exteriors of their property.
So the operative word here, or one of the operative words, is shall. So a landlord shall permit, and then in a container approved by the landlord. Okay, and then noting the suggestions that you just made down below, that's helpful. And then the next, so number 2 on line 13 is a landlord may, not shall, but may authorize a tenant to install a vegetable garden other than in a container. So that seems to give the landlord the ability to simply say, no, you can't do anything other than a container.
Correct. Or you can only do a container in the space that you rent, right? So sometimes that includes outside space, sometimes it doesn't. Sometimes it includes a porch. So tenants aren't always renting out the outdoor spaces. They may be able to use them, but they don't have the exclusive use of those spaces. So I think, I think there's potential there for conflict between tenant to tenant as well. With, somebody ate my vegetables, or uh, did something to my plants. That I have actually run into or on properties where landlords have allowed this to happen. So it does create conflict, even if you don't intend it to.
Uh, Is there anything else then looking down, you already made reference to section little c there, or subsection
Hmm.
little c. A
Yep.
landlord may place, uh, do those restrictions, otherwise look like they would cover the scenarios that you can imagine coming up?
Yeah, I think the only other thing that I would request is something very explicit that the landlord is allowed to collect extra deposit from the tenant if they are putting in some sort of garden. That, whether it's containers or otherwise, there's always a risk of damage. So if it's an actual garden, that's going to be more intrusive into the property. But even planters themselves, if they're overwatered or not cared for properly, can cause damage to the building, and to the premises. And so if the tenant is going to do this, landlord having some higher level of protection, because of this extra add-on, would be helpful and appreciated.
Thank you. Questions from committee members? Yes, go ahead.
You said you just deal with land, you don't deal with HOAs.
I do not deal with HOAs.
So if a tenant wanted a garden, I would think, and the landlord's okay with it, I'll specify some area, because you might put the garden on the leach field, or you might put it on the water line. And that could, something breaks and everything gets wrecked fixing it.
Correct. I mean, rental properties within HOA properties are sort of multiple layers of challenges for sure, because you have the landlord-tenant relationship, but then you also have all the rules and regulations from the HOA. So those are even more complicated. Absolutely.
Representative Bartholomew.
I think I would just echo what you were saying, that it might make a lot of sense to allow deposits, because my own experience is seeing some rental properties as an owner, or I mean, a tenant may have this grandiose idea for a garden, get permission to carve up a piece of the owner's lawn to plant this thing. They raise the bed with soil and then do nothing with it. And then after a while, you got this useless bit of lawn that's full of weeds, and then they leave and the landlord has to clean it up. So it seems like that's probably one of the most common scenarios where people have this great idea to do a garden, but they really never see it produce any food.
Correct. Or it is maintained for a period of time and then it's not, because that particular tenant leaves and doesn't remove the bed structures. Um, it's a more complicated, I think, situation and relationship than, say, somebody who owns a home in an HOA, because they own that home. They presumably are going to live there longer than maybe many tenants live in a place, for sure.
How long have you been practicing this area of law?
I've been practicing this area of law since 2003. And it's been my exclusive practice area for about 15 years. So I've always done landlord tenant, but have moved exclusively into this realm in about the last 15 years. So it's all I do.
And are you here representing yourself or representing a larger group of other people who do what you do?
So I am here representing the Vermont Landlords Association. So we're a trade organization for Vermont housing providers. So generally I'm asked to come in and testify on behalf of the housing provider community, generally private landlords in that regard. But bring sort of a unique perspective and experience because of the legal training and sort of the legal work that I do, which is sort of unusual for someone in my position.
So the folks that are members of the organization would tend to have maybe more than one property or more than a couple of units, or is it everybody?
It's everybody.
Could
I
be
have,
everybody.
yeah, I have everybody from, I have one house that I rent to, I've got 400 or 500 units that I manage, type, and everybody in between, and a couple nonprofit housing providers as well. So it's a pretty wide swath of folks in Vermont.
So even if you can't speak for every individual landlord, you represent a broad cross-section, sounds like.
Correct.
Okay.
Correct.
Can you give us any sense of, like, I have no idea how many rental units there are in Vermont, or how many of us rent as opposed to own our own homes?
Correct. Well, so that's a very interesting question. There's been a lot of back and forth about Vermont and rental registries. So we don't actually have a rental registry in the state of Vermont. The best data that we have comes from the census, and our best estimates is there's about 75,000 rental units in the state of Vermont. But those are just guesses because we don't actually know for sure how many units are rented.
Thank you, Representative Lipsky.
Yeah, Angela, thank you. I have a lot of constituents, so who are tenants and categorize Vermont's rental challenges. And I'm talking about for 30 days or longer. Vermont's laws are very tenant friendly and very not friendly to landlords. It's very burdensome once someone stops paying, etc. But so I'm a little conflicted. I'm a strong supporter of the right to grow food, yet I'm just allowing that we realize that the landlord community is very challenged. And it never occurred to me that what we've been working on for a month could be in conflict with long-term tenants. We hear a lot of blame for short-term rentals taking housing stock from potential homesteaders. But the argument is always, you'd be nuts to be a long-term renter in Vermont because the short-term renter has no rights, if it's for 3 nights or 5 nights. You don't have any eviction challenges or sort of things. Anyway, just reflecting on that, I'm a big supporter of the right to grow food for Vermonters, but I have a lot of empathy for the challenges of long-term.
Yes. Yes, thank you. I appreciate that. I think, thank goodness for all of those folks who are willing to provide long-term housing to Vermonters, notwithstanding sort of the challenges of the business. I did want to raise one, it's not really necessarily related to the bill, but I know a lot of municipalities and other communities have community gardens. So they are setting up space and designating space where folks can rent plots or grow plants or flowers or food or otherwise. And so, you know, those seem like a good avenue as well for people to be able to utilize where the space has already been set up. It's already been designated as with sort of the infrastructure and the ground laid out. So, you know, that's another option here for folks if they're not able to do on where they live currently.
Any other questions or thoughts? We did hear yesterday, Angela, to that last point that there are people who may have mobility issues or for one reason or another aren't able to access as easily a community space. But Yes, Representative Boswell.
Yeah, just, I mean, you were talking a bit about the idea of potted plants versus in-ground gardens. And I know when we had the original walkthrough of the legislative language for, I think, the bill that we have introduced, it talked about having potted plants. And in this committee, we were talking a little bit about why would we have that? You know, that seems weird and restrictive. Hearing what Angela's been talking about, it's like now it's understood. If if you're a landlord and your garden is all torn up and you had grass and it's turned into a garden and then the tenants are leaving, that would be a different kind of disruption. So I think one thing for us to think about is, do we want to go with that level? And then maybe take Angela's suggestion of you need to make a deposit so that somebody can pay to return that to the previous state if you do an in-ground garden, or do we want to keep the potted language for certain sections? I don't know what makes sense, but it is good food for thought. So thank you, Angela.
Yes, you're welcome.
Representative Bartholomew.
You said you're not really talking about condominiums where you own your unit but not land. But can you offer any insight? Are you willing to take a question on that?
No.
Okay, all right, fair enough. It's just one of the challenges. One of the challenges with this bill is how we deal with that kind of situation. So thank you for your honesty.
I think that would be a condominium association and they all kind of run like an HOA.
Is there a parallel organization? I think there is, Angela.
There might be. I don't know who they are. It might be helpful. I know there's a couple of property management companies that help manage homeowners associations and HOAs. Like somebody like that might be helpful to have come in. I think there's one out of Williston, and I think Apple Tree Bay Property Management still manages condo associations. So that might be a useful person to speak to because they're sort of boots on the ground, like behind the scenes with HOAs.
Okay, great. Yeah, thank you. That's helpful. We'll make a note of that and see if we can reach out to somebody who could speak to the first two sections of the bill, or at least section 2. Representative O'Brien.
Angela, do you have any experience in people renting farms?
Only when it goes very, very poorly. And the owner of the property has to ask them to leave, which can be incredibly challenging because we're talking about somebody that comes with a large group of animals that also need to be moved. So yes, with my legal hat, I have done a few of those, but only when the relationship has completely broken down. And it's not a great situation for anybody in that scenario.
Yeah.
Great. Well, I think we can wrap up there. Was there anything else that you wanted to close with, Angela?
No, I don't think so. I appreciate the time to be able to come in and talk about this and provide some information. And I'm always happy to come back on or answer any follow-up questions that folks might have. Always willing to make myself available.
Thank you very much.
Thanks,
Thank
Angela.
you. Thank you.
You think other committees wave to the camera when people are signing off, or is that just something indicative to us?
I think that's a universal. All right, Patricia.
We scream, not to the camera.
Yeah, I wait, I have my back to her.
Yeah, Marco, she's not in the waiting to get back from her second time.